Missing out on family time because of all the noise? Enjoy the moment without straining to keep up with the conversation.
Wow, what a beautiful sunset.
Discover Nuance Audio, the new invisible hearing solution that's built into your glasses. Discreet, comfortable, and easy to use. Nuance Audio glasses help you hear better and reduce background noise, so you can get back to enjoying time with your loved ones. Find a store near you at nuanceaudio.com.
Richard Nixon.
Well, I'm not a crook.
Ronald Reagan.
Tear down this wall.
George W. Bush.
I can hear you. The rest of the world hears you.
And Donald Trump.
And a friend of mine for a long time, he only likes politics. If you ask him about how are the Yankees doing, he has no interest. If you ask him almost anything, he likes politics, and he's a professional at the highest level. Roger Stone.
All of these presidents relied on one man to secure their seat in the Oval Office. That man is Roger Stone. This is the Roger Stone Show on 77 WABC.
Welcome back. I'm Roger Stone, and this is the Roger Stone Show on this beautiful Sunday afternoon. As I said earlier, the so-called hush money trial of Donald Trump opens in Manhattan tomorrow. And joining me now to analyze that particular legal matter, plus the other lawsuits and prosecutions in the tsunami of lawfare against President Donald Trump, is David Schoen. David Schoen is one of the foremost criminal defense attorneys in the United States. He ably served President Donald Trump in one of his 2 impeachment trials. I just flat out say it. He's the single smartest lawyer I've ever met. And being in American politics for 45 years, I've met a lot of lawyers, but David Schoen is that rare lawyer who not understands the law, not understands how to conduct himself in a courtroom, not only understands the importance of legal strategy, but understands that those things that happen outside the courtroom in the court of public opinion also matter. David Schoen joins us on the Roger Stone Show now. David Schoen, welcome.
Thank you very much. Great honor always.
So, David, you people see you on Fox. You have the courage to go in the lion's den on CNN. You're always. I learned something anytime I see or listen to you. You had a great show last Thursday with Laura Loomer on Rumble. Watched that with interest. The case that District Attorney Alvin Bragg has brought against Donald Trump, the so-called hush money case. There's some recent developments in that case. As you know, federal prosecutors looked at the evidence and they declined to bring this case. What is your assessment of that case today?
Case never should have been brought, wouldn't be brought against anybody other than someone with the name Trump. The office itself, the district attorney's office itself, we know from the book written by Mark Pomerantz, special counsel brought in to investigate this thing. We know that Bragg and higher ups in the office, people like before Bragg's time, Cy Vance, the district attorney at the time, thought this case never should be brought. As you just mentioned, the federal authorities, probably the strongest office in the country, Southern District of New York, looked into it extensively, heard from witnesses, sent it to a grand jury, decided there was no crime, bring no charges. Federal Election Commission, no crime, no charges, no civil action should be brought based on this, in contrast to the situation when Hillary Clinton paid money to influence the election. But anyway, I think there are a number of infirmities. I think the indictment is absolutely defective as a matter of law in the case. I think this judge is sitting on this case as a matter of law, and it's gone well beyond now just a matter of judgment. And there are other issues in the case that I think really undermine the state's case. It never should have been brought, but it's brought for political reasons. Alvin Bragg promised to do it when he was running for office, outrageous promise for a government official to make, a potential government official to make, to go after a private citizen who's not under investigation or anything like that, just to pander to the voters. So, I can break down any of these things you like, but that's my evaluation of it.
Now, Judge Juan Merchant, first of all, he gave a campaign contribution to Joe Biden's presidential campaign. Now, it was only $15, but I don't think it matters whether it was $15, $500, or $5,000. The Judicial Canon of Ethics says that judges are not supposed to give political contributions. And then we learned, based on the dogged reporting of Laura Loomer, the independent investigative journalist, but also now encompassed in President Trump's lawyers' motions for the recusal of the judge, that the judge's daughter is an adult, and she is a Democratic political operative and fundraiser who has raised as much as $93 million using this trial as the talking point, as the selling point in her fundraising. Is that not an egregious conflict of interest? And more importantly, should Trump be convicted in a Soviet-style show trial, would that not be grounds potentially to overturn that conviction?
It's absolutely mandatory that this judge recuse himself, disqualify himself from this case. Now that we know what we know. Listen, the lawyers filed a recusal motion earlier in the case. I thought it was weak. Not only was it weak, there were typographical errors in it. The first page said he should disqualify himself from the case because of the appearance of impartiality. It's exactly the opposite. You want him to be impartial. But putting that aside, a lot of facts have been developed in the case. Laura Loomer, did a lot of research and developed some of them. But anyway, the New York Post did an article showing, as you say, $93 million raised by a company that now made the judge's daughter its president, apparently. And what we know now is that she has fundraised off of this. The company has been paid consulting fees by, you name it, who's list of I Hate Trump, Schiff, and others, millions and millions of dollars. And what the statute provides under New York law, 22 NYCRR, the New York Code of Rules and Regulations, at section 100.3 E1D number 3, is that in a case in which a judge has a relative to the 6th degree, that's pretty far out there. This is his daughter, so certainly covered, has an interest that could be affected by the proceedings before the court shall recuse itself. Not a question of just the appearance of impropriety. It's the court shall. And it makes sense. The American public is entitled to believe in the integrity of the system, and the defendant is entitled to have a fair and unbiased judge, not influenced by, or even potentially influenced by, these kinds of factors. So the judge is making a huge mistake. It should be reversed. In federal court, we would take him up immediately on mandamus, or you risk waiving it. But hopefully his lawyers now know something about what they're doing. This judge never should hear this case. And the question also is, why, as a matter of propriety, would the judge hear the case? There are dozens of justices of the Supreme Court, that's the trial court level, in New York County, who could hear this case. This judge wasn't randomly selected. He was handpicked by the administrative judge, chief administrative judge, who picked him for the Bannon prosecution, the Trump Organization prosecution, Weisselberg case originally. It's not coincidental here. And there's a history in this district attorney's office of the district attorney handpicking judges. They claim they don't do it anymore. I don't know. It had to have been challenged. And I think that's another major factor. All of these things, by the way, must be considered cumulatively. The contribution, the campaign contribution, the judge's daughter's factor, and every other factor that's relevant to this.
Look, I'm not an attorney, that's for sure, but I'm still trying to figure out what the underlying crime here. Even if Donald Trump did do the things he's accused of, which he vehemently denies, and which there's a lot of evidence to bolster that claim, late last week, when challenged by Trump's lawyers, prosecutor Bragg presented 4 different theories of the case. I'm not a lawyer, but I thought you needed at least one solid theory of the case. Speak to that, if you would.
That's a huge issue in my view. In my view, that's why this case is dead on arrival. I think it's a matter of due process, a matter of Fifth and Sixth Amendment rights of the United States Constitution, and even under the New York Constitution. The indictment is absolutely defective. No defendant should or could be expected to defend against a charge made out this way. And I'll break it down. The original charge is that the underlying charge is a misdemeanor, falsifying business records. New York law under Section 175.10 allows you to transmute that into a felony if you can show that the defendant falsified the business records with the intent to commit another crime. But an only way to defend that case is to know what that other crime is alleged to be, and the defendant is entitled to have the grand jury specify what that other crime was intended, what the intended target crime was. Otherwise, the defendant's left to wonder, how do I defend? Let's say falsified business records, for what purpose? Well, was it for election fraud? Was it to cover up the Stormy Daniels thing? Was it for tax issues? And so on. And so, as you say, the prosecution listed maybe 4 avenues, and the judge literally in his order denying the motion to dismiss said, well, basically, what do you want? They laid out 4 possibilities for you. That absolutely makes the point. That makes the case that the indictment is defective. It's not only a matter of due process and effective assistance of counsel, compulsory process, right to confrontation, all of those fair trial rights, but it's also to bar against double jeopardy. Let's say he gets acquitted now, found not guilty, and they come back and say, well, what we really meant was the target crime was X, because the judge has said they don't have to specify it. I think the judge is dead wrong. This is a fundamental violation.
Build professional skills this semester with Adobe Creative Cloud and create standout work both in and out of the classroom. Save big on professional creativity tools. Students get 65% off Adobe Creative Cloud, including Photoshop, Illustrator, Premiere Pro, Acrobat Pro, and 20+ creative apps. No matter what project you're working on, Adobe Creative Cloud apps can help you take it to the next level. Visit adobe.com/student to learn more.
In golf, precision is everything, on and off the course. PGA of America chose advanced 5G solutions from T-Mobile for Business for smooth operations and seamless transactions. Together, we enhance ticketing and concessions for better fan experiences from gate to green. This is pro-level efficiency. This is PGA of America with T-Mobile for Business. Take your business further at T-Mobile.com/now.
Morning decisions. A creamy mocha frappuccino drink? A sweet vanilla? Maybe a smooth caramel or that white chocolate mocha. Whichever you choose, delicious coffee awaits. Start your day with bottled Starbucks Frappuccino drinks. Pick up a bottle near you wherever you buy your groceries.
This episode is brought to you by Factor. Optimize your nutrition this year with Factor, America's #1 ready-to-eat meal service. Factor's fresh, never-frozen meals are dietitian approved, ready to eat in just 2 minutes. Choose from 40 weekly options across 8 dietary preferences like Calorie Smart, Protein Plus, and Keto. Eat smarter at factormeals.com/listen50 and use code listen50 for 50% off plus free shipping on your first box. Factormeals.com/listen50. Code listen50. Terms and conditions apply.
It's daunting, folks. By the way, for supporters of President Donald Trump, there is a rally on Monday. Yes, it's called the Hey, 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 it's Fat Alvin Trump rally. That will be from 8 a.m. to 6 p.m. at 130 Leonard Street at Collect Pond Park in Manhattan. If you want to demonstrate against Donald Trump, you absolutely have the right to do that too, folks. But please, whether you're for Trump or whether you're against it, keep it peaceful, keep it civil, keep it respectful. That's how America is supposed to work. We're here with David Schoen, a criminal defense lawyer who very ably represented Donald Trump in one of the 2 outrageous impeachments against him. David, let's turn, if we may, to the so-called documents case. This is a case in Florida. Very strange. The evidence against Trump in this case was elicited before a D.C. grand jury, and then special counsel Jack Smith took those transcripts and had them read to a Florida grand jury in order to secure his indictments. Isn't that a little, unusual?
Most unusual. Never heard of it before. And he clearly has a method to his madness. By the way, I just want to mention, if we have time before we finish, there's another evidentiary issue I'd like to talk about in the New York case.
Let's go.
What I'd like to mention about this case is, because I think the public is really attuned to this, centers around Michael Cohen, President Trump's former lawyer and so on, who himself has been convicted of crimes and went to prison and so on. So I mentioned before, as you did, that the federal authorities reviewed this case and decided not to prosecute. Well, they reviewed it very thoroughly. And in fact, they called in witnesses. They had evidence presented to the grand jury. One of the key witnesses is a fellow by the name of Robert Costello. Bob Costello is a former deputy chief in that U.S. Attorney's Office, well-respected, longtime New York lawyer. And Bob Costello represented Michael Cohen at the time. When Michael Cohen went in and began cooperating with the authorities in the Southern District, he waived his attorney-client privilege with Bob Costello for some reason. So Bob Costello was then called in by the feds to talk about what he knew about the case. And what he told the feds had to have been primary factor in their decision not to prosecute. In fact, he reports they chuckled when he told them what the real facts were. What Bob Costello says is that he told Michael Cohen had said he didn't want to spend a day in jail. And so he told his client, Cohen, I have to act in your best interest. If you really don't want to spend a day in jail, if you have something on Donald Trump, now is the time to help yourself. If you can tell truthfully to the prosecutors that Donald Trump was involved in this Stormy Daniels payment and so on, now is the time to do it. And he said, Michael Cohen told him, I just can't do it, Bob. It's not true. I cannot do that. And Bob Costello told that to the feds. He tried to tell it to the grand jury. He had 300-plus emails back and forth with Cohen, and the prosecutor only allowed him to put on 6 before the grand jury, he reports. And so he told the grand jury the story. The question is now whether Bob Costello will be called as a witness to contradict Michael Cohen. This would be very damning prior inconsistent statements. Well-recognized avenue for cross-examination, goes directly to the credibility of the witness. And at the time, in this case, at the time Michael Cohen made the statements to Bob Costello, he had every reason on earth to try to inculpate, to try to make Donald Trump look like he's guilty if those were the facts. But he said exactly the opposite then. And so Bob Costello should be allowed to testify. The problem here is, are the lawyers prepared for that? Now, I've recently seen a decision by the judge in which the prosecution moved to exclude a lot of evidence from this case, including evidence that the Federal Election Commission reviewed this and decided not to bring any charges, and that the federal prosecutors in the Southern District of New York reviewed it and refused to bring any charges. The judge has already ruled that those things won't be allowed in. But the lawyers told Bob Costello that he won't be allowed to testify either in the case. That makes absolutely no sense. And the question I have is this. When there's a motion to exclude evidence and a defendant wants that evidence to come in, the defendant must make a detailed proffer of evidence. That is, tell the court, if you were to permit this testimony, here's what it would be, and lay it out in detail. How on earth could the defense lawyers in this case have made a detailed proffer when they never interviewed Bob Costello? When they did interview Bob Costello finally, it was clear that they didn't really know the facts. So I'm worried about that. I'm very worried about that. And to me, if that hasn't been done, I know that preparation work hasn't been done. If the proffer hasn't been made properly, I believe there's a true claim here for ineffective assistance of counsel. So President Trump needs to be represented at the highest level in the strongest terms possible. The country demands it. The integrity of the system demands it. Bob Costello is ready, willing, and able to be a major witness in the case. Look, we'll see what happens when Michael Cohen testifies, but he certainly knows that's out there, and the feds certainly know it's out there, and they certainly have notes reflecting Bob Costello's statements to them. So that's an issue to keep your eye on. And will Bob Costello testify in this case to contradict Michael Cohen?
All right, folks, you heard it right here at 77 WABC. We're making news. That was newsworthy. There is a very respected former Justice Department official, Robert Costello, who later worked as a defense lawyer. He's extremely respected at the bar. He could easily debunk many of the claims of Michael Cohen based on what Attorney Schoen has just told him, but it's unclear whether he's being asked to testify. It's unclear whether the judge is going to allow him to testify. It's unclear whether Trump's lawyers have made a proffer to the judge to explain why his testimony is relevant and important to the case. First time I've heard this, but you heard it here first on the Roger Stone Show at 77 WABC. Okay, David, let's go back for a moment to the so-called documents case. The special counsel, Jack Smith, went out of his mind when the judge in that case, Eileen Cannon, asked both the prosecution and the defense for potential jury instructions. Not that she's decided on jury instructions, but in one of her proposed orders, she references the Presidential Records Act, which, of course, President Trump and his lawyers contend would make him immune for prosecution in this case. And Special Counsel Smith essentially appeared to me to legally threaten the judge in his filings. I'm an amateur at this, but I've never seen anything quite like that. Your reaction?
He was way out of line. He's taken this position because he's quite afraid, obviously, of the Presidential Records Act being a factor in the case. And so he's taken the position that it has absolutely no relevance to this case. Well, he's just wrong about that. There's a case from your old friend, Judge Amy Berman Jackson in D.C., that says quite clearly that under the Presidential Records Act, there's only one person named who can designate the status of records, whether they're presidential or personal records, at that person's discretion. And that person is the President of the United States. Therefore, it would be directly relevant if Donald Trump, as President of the United States, designated records that he was holding as personal records. Someone might disagree with it. But what she said is the president is the only person with the discretion to do it. This is directly relevant to the mens rea, or the mindset of President Trump with respect to these records. And that is a mindset that the government has to prove. They have to prove that he knew he was doing something wrong when he kept these records. And that's not the case. He was given advice, direct advice from lawyers. Some lawyers said one thing, some lawyers said another. He's entitled to believe the lawyers who he thinks make the most sense and rely on their advice. And they told him that he was entitled to have these records. And he believed that. So that would be a complete defense to the charges in this case. I would say this, it's in direct contrast to the life experience of President Biden. As you know, President Biden was caught with National Defense Information records and classified documents, apparently, which he held not as president ever. This was as vice president or senator. And if anybody should know that's illegal, if it's illegal, it would be Joe Biden. He spent his entire life in government. Donald Trump was a businessman who just came to the government. I think Jack Smith is panicked about the Presidential Records Act, and the judge took a lot of criticism for what she did. But, take a step back. This judge is kind of the American experience. Daughter of immigrants, worked her way through top schools, clerkship, was a prosecutor, and so on. She's no dummy. She gets maligned in the press because she seems to be the only one making straight, up the middle decisions in the case. I thought that her idea of having them present jury instructions was very clever. Many lawyers start to prepare their case with jury instructions to get a sense of the law, the parameters of the law around which they have to build their case. I happen to start with a cross-examination approach, but some lawyers do it with jury instructions. And she said, well, these are going to be big issues in the case. Let's see how you think it plays out and how these issues should be presented to a jury.
All right, folks, if you're just tuning in, I'm Roger Stone. This is the Roger Stone Show. We're here with criminal defense lawyer David Schoen, and we'll be right back. We're back, folks. This is the Roger Stone Show at 77 WABC. Take a quick minute to go to the App Store and download that 77 WABC radio app so you don't miss any of the extraordinary talk or entertainment on the most powerful, dynamic AM radio station in America, 77 WABC. We're here with criminal defense lawyer David Schoen, who very ably represented President Donald Trump in one of the two impeachment trials before the U.S. Senate. And we're talking about various aspects of the legal tsunami of lawsuits and prosecutions against Donald Trump. We're talking about the case playing out in Florida, the so-called documents case. There were, as I recall, there were several motions to dismiss this case by Trump's lawyers, one of them being based on the Presidential Records Act, citing the fact that Judge Amy Berman Jackson ruled that Bill Clinton could do anything he wanted with his documents, including keeping them in a sock drawer at his home as a precedent. But they also argued that this case should be dismissed on the basis of selective prosecution. There is no question, if you will read Special Counsel Robert Hur's report, that he bluntly says that then Vice President Joe Biden willfully retained classified and top secret documents in violation of the law. So how is it that Donald Trump, who may have been actually entitled to keep those documents under the Presidential Records Act, is being prosecuted, but Joe Biden, who the special counsel says definitely broke the law, he's not being prosecuted? Does the fact that the judge has asked for these jury instructions means that she has elected not to dismiss the case on any basis?
No, I don't think so at all. And furthermore, I think what she has decided with respect to the Presidential Records Act is that this is a real live issue in the case. She may not dismiss it. She may not find immunity based on it, but she believes it's a real live issue that should be presented as to his state of mind and to the jury. And with respect to the selective prosecution, you could hear from the oral argument that she was very offended by that. This is an issue that plays well beyond this case. I think it's a very important political issue because the public now knows that the special prosecutor, Mr. Hur, Joe Biden broke the law, period, end of story. He didn't prosecute because he said, as you know, and whatever the terms are, I'm paraphrasing, that Joe Biden would be presented as a feeble man with a poor memory to a jury and therefore would be sympathetic, and they didn't think they could get a conviction. Let the American people judge whether that's an appropriate reason not to prosecute and whether that's a broader statement about President Biden and his ability to stand as the president of the United States now and in the future election. It's a very important issue politically also. But I think on a gut level, the selective prosecution idea really hits people wrong. Why? There's no real justification. The prosecution, Smith has said at some point, well, but President Trump didn't give back the records. Number one, he thought he was entitled to keep them. And number two, the charge isn't just about not giving back the documents. It's about holding national defense information that a person wasn't entitled to hold. Joe Biden, according to the special prosecutor, absolutely did that and absolutely would have and should have and did know better. So we'll have to see how it plays out. I don't think she's going to dismiss the case on selective prosecution because the standard is very, very high, and we look at protected classes, that sort of thing. The law is just not great on it. There's a great deal of prosecutorial discretion that the law permits. But in this case, I think it hits everybody as extraordinarily unfair. Just one more unfair factor is about all of these cases.
Let me make one more comment before we have to go. I find it interesting that Andrew Weissman and Neil Keitel and others attack Judge Cannon because she was appointed by Donald Trump. But they seem to ignore the fact that every judge who sat on a Mueller investigation case was appointed by Barack Obama, and the Russian collusion hoax under which most of them essentially, including myself, were prosecuted was hatched in the office of, well, yes, Barack Obama. That's in Special Counsel John Durham's report. But it didn't seem to bother them that we were going to trial before judges appointed by Barack Obama, who is the main perp in the Russian collusion hoax, egged on by James Comey and, of course, CIA Director John Brennan. We'll have more to talk about him later in the program. Let me thank my guest, David Schoen, for joining us on this beautiful Sunday afternoon. David Schoen, anytime I listen to you, I learn something I didn't know. I want to thank you for taking time from your busy schedule to join us today on The Roger Stone Show.
Thank you very much. You do a great show.